believe true threats.
Do we owe any deference to the decision of the DCA in this case?
It's helpful in examining that the standard of review is de novo, but it's also helpful to look back to the standards that were provided and the ruling that was provided by the lower courts. And ultimately, furthermore, the fact that the victim secured a restraining order herself against the petitioner also suggests that the statement should be viewed as a threatening nature. And this does not preclude the fact that the petitioner himself added his own disclaimers to the bottom of the communication, suggesting that he may have considered, and in fact did consider, that the statements would be considered by others as threatening. And it is because of these reasons that the great deference and the Cosma test, we see that indeed his communications are seen as truly threatening. Now, in concluding the question of the nature of true threats, it should be noted that the court in Martinez found that, quote, a true threat is a communication that, when taken in context, would have reasonable tendency to create apprehension that its originator will act according to its tenor, end quote. In this, the court set forth that when a statute articulates no specific mens rea requirement, it is appropriate to treat that statute as a general intent crime, a classification which does not require proof that the communicator subjectively intended the precise purpose or results of the crime threatened. Now, finally, there's another aspect of this which proves
consider subjective intent. Can you even testify to it?
The subjective intent, personally, we believe that an objective test should be used. However, within the two different tests, we've already examined the reasonable person test, which is the objective test, but also the subjective test is adopted only by the Fourth Circuit Court of Appeals of the United States, and it's been labeled less favored and problematic on the grounds that it requires proof that the speaker intended his statement to be taken as a threat, even if you had no actual intention of actually carrying it out, as Rogers, the United States, laid out, and that the above requirement could seriously compromise the safety of those to whom threats are being made. And it's on that ground that we deny, or at least we ask you to deny, the subjective test and go with the objective test in a more light and positive manner. Now, in conclusion, thus, in applying a plain reading of the Florida statute, the three-part test, the reasonable person test, and the willfulness standard, it may be clearly seen that recklessness alone, absent intent, is indeed sufficient grounds to sustain a conviction under Florida Statute 784.048, and thus that the communications of the petitioner necessarily fall outside the bounds of protected speech under Article 1, Section 4 of the Florida Constitution. Now, we as the respondent ask respectfully that this court affirm the findings of the lower courts and uphold the convictions of the petitioner.